Welcome. This is a briefing on some elements of the government's workplace reforms, where we also touch on some other developments that will affect members. I'm Richard Calver, a NatRoad advisor, and the webinar will be jointly presented today by Edmund, the main NatRoad advisor. He'll talk about the respect at work elements of the reforms and present the conclusion. As part of the conclusion, he'll foreshadow other webinars on this subject. Those webinars will be presented by external providers of some of the services we think members might need. But before we get into the substance of today's webinar, I must say that this is not legal advice we are presenting, and any issues that arise for your business need to be a subject of specific advice. That can be provided in general terms by Edmund as the NatRoad advisor and by NatRoad service providers on legal matters. So, today's presentation focuses on issues that have been sparked by comprehensive workplace reforms that have been introduced by the Labor government. And this slide speaks for itself. NatRoad's urging members to review their employment contracts, as we will explain in more detail, but also before the unfair contracts legislation, which is mentioned in dot point 3, kicks in from November 2023, we're urging members to review their commercial contracts, particularly those with subcontractors. We also strongly advised if your contracts are currently verbal, then consider putting them in writing. And that's particularly the case if you engage owner-drivers, where in Victoria, for example, it's mandatory to have written contracts. The days of doing business on a handshake are sadly no longer viable. So remember that if you believe the unfair contracts legislation might be irrelevant to you, it's worth noting that from November 2023, the law of unfair contract terms will expand to apply to all small business standard form contracts entered into where a contracting party employs fewer than 100 people. So that's a huge conspectus. That's increased from 20, or where the business has an annual revenue of less than $10 million. So the value of the contract will no longer, for most transport contracts, be a consideration. Currently, that's a major restriction to the application of the unfair contracts law. For the unfair contract terms to apply now, the small business contract, where it's for less than 12 months, must have an upfront price payable of more than $300,000, or currently, if it has a duration of more than 12 months, the value must not exceed $1 million. It's very important, therefore, that you have both your commercial contracts and your employment contracts reviewed, particularly the commercial contracts, because the maximum penalty for getting it wrong has been increased to a maximum of $50 million. So the next section talks about the WR reforms that are currently in place or are being implemented over 2023. These changes are fundamental. They change the law of workplace relations fundamentally. So the approach today is to tell you what reforms are currently in place and also about those to be introduced over time, mentioning some reforms only in passing, but fleshing out some of the major reforms. So, in force now talks about a number of changes to the law. First, you can't stop people talking with others about how much they are paid, or you can't put in contracts that their pay is a confidential matter. So pay secrecy provisions are unlawful. This needs to be checked because there are penalties for non-compliance if you do put it in an employment contract. Hence, our emphasis on getting a review of both your employment and commercial contracts. Secondly, members should assess how pay transparency might affect your employee morale or cause bitterness in employee communication. The government has this measure aimed at highlighting any differences in male and female pay, an issue of discrimination. But there's also in the strengthening in the new law of pay equity aimed at closing what they call the gender pay gap. That is also the point of the second dot mentioned there, strengthening the anti-discrimination provisions of the Fair Work Act. The other two dot points are self-explanatory, and we'll deal with them in greater detail as the webinar moves on. We speak further about enterprise bargaining later, but there are massive changes to enterprise agreements. And the other dot point relates to new penalties imposed on employers who advertise employment opportunity at a rate of pay that will contravene the Act or a Fair Work instrument. By a Fair Work instrument, we mean one of the transport awards, for example. So check the rates of pay with NatRoad before placing an advertisement, and we can help you. So, March this year, there are new sexual harassment and discrimination laws in place. Edmund will expand on this slide later, but now the Fair Work Commission can deal with sexual harassment, not only the Human Rights Commission or a court. In June, the bargaining system will change completely. The June 2023 timing for bargaining changes and enhanced employee rights to request flexibility at work will both be expanded on later in this webinar. This slide shows that there's a game changer for those who believe that they've been underpaid. There is better employee access to the small claims procedure set out in section 548 of the Fair Work Act. Employees are able to commence their own legal action against their employer to recover underpayments, and they can do that in the federal circuit, in state and territory magistrates courts, or their equivalent like the local court in New South Wales. In this instance, the court is not bound by the rules of evidence and can act in an informal matter without regard to legal forms and technicalities. Parties need to obtain leave to be legally represented when the small claims jurisdiction's invoked. An employee can remember, go back 6 years alleging underpayments. And an employee can also get the benefit of a court-imposed penalty, which is mentioned in that slide. This next slide is about changes to fixed-term contracts. These are a fixed-term contract of employment. That is one that will terminate an agreed period from commencement, just, for example, a 6-month or 1-year contract. They operate so the employee cannot sue for unfair dismissal if the employer decides not to offer fresh employment or a new contract of employment. So they've proven popular. So popular, in fact, that this measure has been introduced. Check your use of these contracts because the new provisions limit their use for the same role or similar work to 2 contracts, one after the other, or a maximum duration of 2 years. There are exceptions, one of which is mentioned in the slide, and that's essential to workforce planning. That's a peak demand issue. Talk to NatRoad if you want to put an employee on a fixed term contract, particularly as employers will be required to provide employees with a new information statement called a fixed term contract information statement before as soon as practicable after the contract is entered into. We now home in on some of the bargaining changes that I mentioned earlier. So this slide aims to direct members' attention to whether they have an enterprise agreement in place and how we recommend putting an agreement in place to secure some ongoing certainty in employment arrangements. There's a major focus in all of the commentary, some of which you might have seen, on what are known as multi-employer bargaining agreements. But the changes go beyond this and include reduced barriers to the Commission's arbitration, the Fair Work Commission, and changed approval processes for agreements. Importantly, employers who have previously bargained with employees have fewer options to resist bargaining for new agreements, and that's expressed in dot point 3 on that slide. So the main point is for you to first check if you have a replacement agreement. This is defined as one that will replace an existing agreement which had a nominal expiry date within the last 5 years, which covers a substantially similar scope of employees. So this talks about an employee bargaining representative being able to initiate a bargain for a single enterprise agreement where the new agreement would replace that early agreement. So that's why we recommend that if you have an expired agreement or a zombie agreement, you establish a new bargain directly now with your employees to avoid some of the changes that are coming. Where there is a replacement agreement, bargaining will commence on written request from an employee bargaining representative, as I said, most likely a union representative. In addition, members with 19 or more employees are at increased risk of being included in what are known as single stream multi-enterprise bargaining arrangements. Rather than go into the intricacies of how this is to occur, many members may be faced with the situation of being compelled to bargain together. Let me just put it out there. We already have industry awards setting minimum wage outcomes. In time, it's likely there will be in place industry agreements setting actual wage outcomes. Get a health check via NatRoad. That'll be articulated in some detail by Edmund. And also, we suggest enter into an enterprise agreement as soon as possible now to avoid early roping into an agreement that others initiate. Having said that, there is one other element in play here. The Fair Work Commission can amend proposed agreements itself to amend or remove terms which don't meet the better off overall test. This means a proposed agreement won't need to be voted on again by employees. That presents the risk that bargaining representatives via union may want to change what an agreement looks like after it's been approved by employees. Again, another reason to enter into an agreement now. There is also the ability of the FWC to reconsider the boot. New employees who engaged after an agreement has already been measured against that boot can apply for reconsideration. So now I'll move to Edmund, who'll talk to you about respect at work. Edmund.
Thank you, Richard. Let's look at the implications of respect at work for NatRoad members. The cornerstone of the respect at work legislation is the inclusion of a positive duty for employers and persons conducting a business or an undertaking. And the requirement there is to take reasonable and proportionate measures to eliminate unlawful sex discrimination, including sex harassment, as far as possible. So it's no longer a reactive responsibility. Namely, we wait until a complaint is made and then investigate it. Instead, it is a proactive and positive duty to shift the focus to prevention and the responsibility from those who experience discrimination and harassment to those who are best placed to prevent it, namely managers, employers, and principals who engage contractors. In slide 18, you will note that the Australian Human Rights Commission will be given the power to monitor and make an assessment of an employer's compliance with their new positive duty. And that will include the ability to conduct inquiries, to issue compliance orders, and to enter into enforceable undertakings with a business. These new powers will include the right to require companies to provide information, to produce documents, and to examine witnesses. The unions will be able to make a court application on behalf of their members who have experienced unlawful discrimination, including sexual harassment. And the court has the power to award compensation. Employers may now be exposed to pecuniary or financial penalties separately from the substantiated injuries or damages, as workers can pursue their claims through Fair Work, the Australian Human Rights Commission, or the relevant state or territory anti-discrimination processes in the courts. At both federal and state levels, workplace health and safety laws now consider sexual harassment and associated issues as a psychological hazard. This reflects the need for employers to consider it in the same measure as a safety risk and to manage it by implementing a hierarchy of controls. Employers can be held vicariously liable. Now, vicarious is just a big legal word to say that a third party can be held accountable for the actions of, for example, a subby or an employee. So employers can be held vicariously liable for the acts of employees or agents within this new jurisdiction, unless they can demonstrate that they took all reasonable steps to prevent such sexual harassment from occurring. So to discharge your positive duty and avoid exposure to claims for injuries and damages, we recommend the following. Firstly, implementing a standalone prevention policy. And by standalone, we mean it cannot be included in sexual harassment, bullying, and victimization. It must be a separate sex discrimination and harassment prevention policy, separate from normal bullying and harassment. Also have regular training for all employees at induction, as well as an annual refresher. And then a very important training for the leadership team who will be dealing with those complaints. Richard will now take us through the flexibility at work provisions. Thanks you,
Edmund.
Richard.
Thanks. So yes, next we're dealing with flexible work arrangement requests. And basically this requires now a very hands-on approach. So first of all, the requirement is in the legislation as part of the national employment standards, below which you cannot employ people, hence the floorboarding at the base of each slide. It says that permanent employees who've worked with you as an employee for at least 12 months can request flexible working arrangements. And given the aging of the population in the transport industry, the one that really sticks out from that list is the right to request flexible work being vested in those who are 55 years and older. So your employees who reach that age can request flexible work if they've been with you for at least 12 months. So there are new provisions in these workplace reforms, and they're quite prescriptive about what you must do, and they require an employer to have reasons for denial of these flexible work requests, and a denial that you can show objectively to the Fair Work Commission is valid. So before you do anything in response to a flexible work request, discuss the fact that you've received that request with a NatRoad advisor before you put the detail on paper, and you'll note that you have to respond in writing now to these requests. So if you still, after receiving the request, intend to refuse the request, you've got to outline what's known as a reasonable business ground for refusal and address particular criteria that are now set out in the legislation. And you've got to have a response back to the employee within a required period of 21 days from the date of the request. If you don't do that, there's a potential fine involved for you. So the first thing to do is assess current processes for handling such requests, make sure they conform with the process that I've just outlined in those slides, and make sure that acceptable business grounds for any refusal are legitimate, objective, and include matters such as that the change could cause a significant loss of productivity or have a significant negative impact on customer service. And also, if they're long distance driver, that it's quite difficult to comply with the long distance award part-time provisions. And so you could make a condition of the flexibility that there be an individual flexibility agreement entered into in relation to the flexibility that they seek to overcome the award stringencies. But the long and short of it is, if you receive a request for flexible work, call a NatRoad advisor. So from what we've just heard, the introduction of workplace relations reforms means that employers should now be actively looking at employee and, as I mentioned earlier on, commercial contracts, as well as documenting practices and procedures that will apply as the workplace reforms roll out over the year. That is, especially the ones that are in place now, but really from June and December 2023, but for unfair contract provisions from November 2023. So, Edmund, before we go to questions, could you please summarise what facilities are in place for further member assistance?
Thank you, Richard. There are 2 remaining webinars in our Workplace Reforms Made Easy series. The next webinar is on Tuesday, the 14th of February. It is at 11 a.m. Sydney time. It's on Valentine's Day, so easy to remember. It will be hosted by Australian Business Lawyers and Advisors. In short, their name are called ABLA. They have a strategic alliance with Business New South Wales. However, they represent businesses all over Australia. They have offices in Sydney, Melbourne, Newcastle, and Brisbane. Their managing director, Louis Izzo, and his team, they will take us through practical focus, specifically on solutions designed for NatRoad members. So it will not be a theoretical or academic presentation, but all practical and also promoting the services they provide. On the day, they will specifically focus on enterprise agreement making options, either establishing a new agreement or a replacement agreement. Then they will talk about the legal implications of respect at work, as well as flexibility at work, training for leadership teams, as well as the documentation required. They will talk about commercial contracts and how to avoid using unfair terms. And lastly, finish with data breaches and cyber security compliance. The last webinar is on Tuesday, the 21st of February, again at 11 a.m. Sydney time, and that's hosted by Level Up. Level Up is people and business growth advisors. They're a group of advisors across Australia. They have a presence in Brisbane and Perth. Justin Prince and the Level Up team on the 21st will again focus on practical assistance that they can provide with enterprise agreement making, as well as training on respect at work, flexibility at work. The last element they will talk about, Richard, is HR services like wage benchmarking or employee engagement services. Now, members might be asking, how do you book these services? The process is you first book a 1 hour long, no obligation consultation with myself, where we discuss your business, your agreement, your situation, what you may require. We then provide a quotation on those services and make further service arrangements. You can book that 1 hour free consultation either by emailing info@NatRoad, or you can simply call the office to book a consultation. Thank you, Richard.
Thanks very much, Edmund. So we try and keep these webinars to 30 to 45 minutes. So we've allowed some time for questions. So Michelle, do we have questions?
No, we don't have any questions. If anybody would like to type in a question in the Q&A section at the bottom of the screen, you're welcome to do that. Otherwise, if you would like to email info@natroad.com.au, you are welcome to type in your question there and we will pass it on to Edmund. You can also, of course, call him on that number and we will put your call through so you can have a chat to them. And the webinar is also recorded. So if there's anything that you've missed in this, please have a look at the Workplace Relations page and we will send some more information through on those other webinars coming up as well so that you can register for those. Well, we have one question that came through.
Great.
Wonderful. Will there be a template for respect at work policies we could use?
Edmund, I'll shoot that question to you.
Certainly, Richard. Yes, NatRoad is working with our service providers to provide documentation and services due to the increased legal complexity and the manner in which you can be engaged either by the union on behalf of members or in different forums. It is very important that the documentation is prepared by a legal qualified professional. So we will be able to provide guidance and advice with regard to that.
Thanks, Edmund. So that will apply to subbies as well, a contract template?
Yes.
Wonderful.
And customers, that's the other issue, that the reach of the duty is quite extensive and quite new. So that reinforces what Edmund said, just a simple template won't do. It needs to be tailored to the particular business.
Exactly, Richard. And perhaps just to demonstrate the complexity with regard to that, let's say you as an employer do the right thing and you introduce a policy, you train your employees and you train your managers in dealing with that. And now some manager says something and you are engaged as a business, you will then need to demonstrate that you as a company have successfully discharged your duties, and the person who then made the comment, it's for that person to answer. And that is where the complexity comes in and why those policies need to be customized and be prepared by a legal professional.
Great, we've got another one. Where can we find detail on the new legislation?
Well, we've got a homepage on this subject with fact sheets. And then, as Edmund said, we've set up an hour-long consultation so that you can talk about your personal circumstances with Edmund, and he can then seek to have advice tailored to the individual member's needs. Edmund,
Wonderful.
you want to expand on that?
Yes, Richard, we had a mail out to all members where we included the infographic as well as a table summary of all the legislative changes. The fact sheet is loaded up onto our website, and then the Department of Employment and Workplace Relations also have a series of fact sheets that they have prepared. So the simple way, Scott, just send an email through to info@NatRoad, and we can send that information on to you. Or if you want to book in a consultation, we're happy to talk to you.
Wonderful. And members, if you could please just keep an eye out on our emails as well, because we will be sending out a lot of information, not just to register for the webinars, but any other services that become available, just to remind you of what's coming up, will be sent to you as well. I don't have any other questions, so we might conclude with that.
One
Edmund
showing in the
Richard?
Q&A. There's one showing.
It's a thank you.
Oh, okay. Sorry about that.
Wonderful. So yes, please, I mean, this is complicated stuff. So please send us your questions via email, info@natroad.com.au, or please give us a call. We'll be happy to help. Thank you, Edmund. Thank you, Richard.
Thanks, Michelle. Thanks, Richard.
Bye-bye.
Thank you, members.
Bye.
Thank you, everyone, for attending.